The Citizenship Ammendment Act, or the CAA, has been a subject of much controversy and even protests across the country. A law that was passed by both houses of the parliament has not been notified yet, which means it's a law only on paper right now and hasn't been implemented as yet. Hello and welcome to this edition of Let's Talk Law. I am Anusha Soni. Today, we decrypt the much talked about CAA, the controversy around it, why the law remains so controversial, and why has the government hesitated in the implementation of the law despite it being passed by both houses of the parliament. Legally speaking, how has the government defended this law in the Supreme Court of India, where it presently stands challenged? The basics first. Before you understand the Citizenship Ammendment Act, let's briefly talk about the core act, Citizenship Act 1955. This act or law of India governs how citizenship can be granted to individuals. And the 2019 law is the amendment to this core act. Well, for most of us who are born in India, we have never had to bother about citizenship. It was a given. With the birth certificate, Aadhaar, even a voter's ID, we could always apply for our passport and accrue any government benefits that we wanted. But there are many people who acquire citizenship. Suppose somebody is married to an Indian citizen and wants to acquire Indian citizenship, or somebody who took refuge in India and now wants to acquire citizenship. There are primarily 4 ways to acquire Indian citizenship: by birth, by descent, which is when your father is an Indian citizen, or by naturalization and registration. Now, these are the 4 basic ways. Let's now address the elephant in the room. Why is CAA controversial? What are the changes that it has brought to the core law of 1955? Now, to understand it, broadly, there are 5 key legal changes to the various provisions of the 1955 Act that have been made through the 2019 amendment. Through these changes, here is what the government has done. The core change that the CAA brings in is that it provides a certain kind of security and protection to Hindus, Sikhs, Buddhists, Jains, Parsis, and the Christian community from Afghanistan, Bangladesh, or Pakistan from being declared as an illegal immigrant in this country, which means that they are protected to a certain extent from deportation and may be able to get the state benefits available to refugees far more easily than other communities. The same kind of protection or immunity is not available to Muslims who may be fleeing from these countries. The cutoff date has been identified as 31st of December 2014. Cutting through the clutter, the key criticism of the CAA has been that it singles out some communities, grants them benefits and the possibility of applying for registration and citizenship while excluding the others. Many critics say that this provision of the CAA is against the principles of secularism in Indian Constitution. Secularism, which has been termed as a basic feature of Indian Constitution. Primarily, this was the reason we saw widespread protests across the country, and it was the Muslim community that had vociferously opposed this law. Can the government really defend a distinction based on religious grounds? Is that legally permitted under the Indian Constitution? Presently in the Supreme Court, this law stands challenged, and as expected, the government has defended the amendment. Here is how the government has defended the Citizenship Ammendment Act 2019. Now, the government argues that the elected representatives have the power to give special protection, especially to the vulnerable groups. The government tells Supreme Court that if the government has valid grounds to make a classification, and that word is very important, to make a classification, and there is a reasonable nexus with the object of the law, the government is well within its right to make a classification. The classification can be drawn based on demography, linguistic or geographical identity, depending on historical factors. Now, simply put, the government is saying that Hindus, Jains, or other communities mentioned in the CAA have faced a special kind of persecution in countries like Pakistan and Bangladesh, and India, on humane grounds, must reach out to these communities. It is the right of the legislature to make this classification. The government further goes on to say that right to equality does not mean a universal application. The state has the ground to make classification, and it asserts that the government of India has done its due diligence. Coming to the second limb of the argument, there was another sentiment or argument that clearly echoed during the anti-CAA protests. that it somehow affects the legal status of Muslims presently residing in India or may affect their rights in the future. The government on record tells the Supreme Court that through CAA, the old mechanisms of obtaining citizenship have not been done away. Neither the amendment affects the rights of Indian citizens in any way possible. The government has also said that even earlier, through notification, the central government has expedited the process of granting citizenship to certain communities mentioned in the CAA. And this move of the government via amendment is only a legislative assertion of an existing position. Now, the government says the problem of these communities has been historically recognized by the governments, but never systematically addressed by any of them. Now, contrast the position taken by the government on CAA with respect to certain communities mentioned in the 2019 amendment to what the stand of the government has been on Rohingya Muslims in India. Does this mean that India has no refugees from the Muslim community, or India has not honored its international conventions to which it's a signatory of? Now, contrary to the popular perception, India continues to give shelter and refuge to persecuted people from all communities. Legally speaking, there is no legislation per se that defines the word refugees, but the legal status of such immigrants in a country like ours is determined by a special tribunal on a case-to-case basis. Not to forget, India is also home to about 15,000 refugees from Afghanistan in honor of its international commitments, according to the UN refugee body. Now, the criticism of CAA is about shifting paradigms. First, it was about the fear that combined with NRC, it could affect the citizenship of Muslims in India. Then the argument of whether it violates the secular principles of the Constitution, and then about the non-compliance of international conventions. Whether any of this holds merit will be decided by the Supreme Court. But the government remains firm that the amendment has a specific aim and purpose, and the government has the right to make such a law.